Jonathan, where is Champion?
He's with the girls. They are eating, and so I think he thinks he's got a good chance of getting something special.
There, just in case.
Yeah, exactly. I got your message. You should be able to do it, and I can walk us through when we get to that point for the sharing.
Alrighty.
Diane, do you know if Andy's coming to the meeting too?
As far as I know, he said he was.
Okay. I got double booked, so I was wondering if I could change the host to him after we get going here.
Mm. And where's Carmen?
I don't know. I was wondering that too. There's Andy.
No, it's Pamela.
I'll get him. I'll get him squared away here. Andy, would it be all right with you if I switched you to the host so I could help Lindsay with the EDC meeting? She's having some difficulties over there. You're on mute.
All right.
Yes, that's fine.
Okay. I'll be back as soon as I can get here.
What about the share thing?
That's going already. We're live streaming right now.
No, the document that Carmen wanted to share.
Oh, on the bottom in the middle of your screen, there's a green share screen button with a little arrow. When it comes time, all you have to do is hit that button and it'll come up with the screen, and then you just pick the document you would like to share, and then it will let you.
Okay, I'll try.
I'll probably hopefully be back before you have to do that.
Okay.
Hey, John, is John still on? No?
Left for a moment.
Oh, okay. So Ben's got an audio problem. You seeing that? Hey, Ben, I think the invitation has a phone number that you can call to get the audio.
It does.
Yeah. So do you have that email invite, Ben? Maybe we can, someone can write down the phone number and hold it up for Ben. Looking for a card. Oh, he left.
He's on mute. Is it just a matter of him unmuting?
I think he also cannot hear, but we'll see. We'll come back and it's like charade. No, it's not charades. What is it? Pictionary. That's what I'm trying to think of.
I used to love that game.
There he is. He's got his phone. Let me see here. Ben, I'm going to try to get one of the phone numbers. Of course, none of them are Colorado. Let's see.
I'm assuming I'm working.
Yes.
Hey, Cameron or Andrew or anybody, can y'all hear me?
Yes.
Yeah.
You can't see me though, can you?
No.
No.
Yeah, I'm having troubles. I'm gonna have to reboot my camera up. It would take about 15, 20 minutes to do, so. Brand new laptop, should work.
We don't need to see you.
That's probably better.
Do you see Ben's question about the Houston number?
Yeah. This, oh, look at this. Oh, it's backwards. Why is my note backwards?
It looks fine from here.
Okay. Further up.
Nope, hold it still.
I'm trying.
It looks backwards to you because it's in your camera.
All right, let's see. I'll try this out.
Like Mike might be having trouble connecting to audio as well. He's been connecting to audio for a while. Not sure what's up with him.
I wonder if you click that button that says connect through computer audio, sometimes that hangs up my Zoom
Yep.
for a while. Tech is great unless it doesn't work well.
Are you still on, Diane?
Yes.
Okay. Nope, there you are.
If you all heard chainsaws all day long, that was my house today. Super fun.
What was going on?
We trimmed 5 giant trees. So tomorrow there will be jackhammers. That'll be
Oh
fun.
my.
I'm about done. I'm ready for snow. I can have a little less noise.
What noise is worse?
The Sanders all summer on my house. Those were the worst because they vibrated the house and my ears. I ran away from home a lot. It was hard during COVID. I'm like, I need to go somewhere. It's all getting better.
Joe Biden is the president-elect, which you can hear pretty much on any news station, even on Fox. It's pretty clear. He is.
Is that Ben?
I guess.
Ben, can you hear us? You can hear us?
Ben.
Oh, there he is.
He's muted though.
Yeah, Ben, you're still muted. Also, there's a chat. You can go to the chat. Oh, okay.
Now he's unmuted.
Hey, Ben, is your number 641-4338?
Yes, can you hear me?
There
Yes.
we go.
Okay.
Now we can.
Good job.
Oh, don't end the phone call. That's how we're hearing you.
Oh,
All right.
Ben, can we still hear you?
I think did you hang up, Ben?
Tell them to call back in.
We have to see your little telephone number in a square to hear you.
Yeah, call back in, Ben, and put it on speaker.
I don't think he can hear you.
I don't think he can either.
Oh, you can hear?
Yeah.
Oh, okay.
So you can hear us, but we can't hear you. That's weird. And he's not muted. Maybe he has a microphone problem?
If folks can hear me, which I think Ben can.
I can hear you.
Chair, we can, if you're comfortable proceeding while he sort of gets his ability to communicate with us, I can launch in with my sort of spiel here, because my plan was to sort of go through some things, and while folks could interject if they wanted, certainly we can have sort of a Q&A period at the end, but I could, as long as Ben can hear us and multitask, I don't think he will lose out if you want to begin anyway. I could start my little spiel.
Yeah. Ben, can you still hear us? Just shake your head. Okay. Yeah. Why don't we get going, Cameron?
All right. So I think we are, John's hosting. We're staff, maybe Diane or someone, you can confirm for me. We're on. I see the little YouTube thing up in the corner, but we're good to go.
Good to go.
Okay. Very good. Well, Chair, if you are okay with me just sort of launching in, no, we're in a work session, aren't we, Diane? Do you need roll
Yes.
call or anything?
No roll call.
Okay.
Hey, Cameron, before we begin, I have a new member too that wanted to join. He just texted me. He's having issues getting on the phone.
Okay.
Or getting on the call. He does want to, his name is Jerry Furberg.
Okay.
He does want to be a member, and he's going to submit his letter to me or Diane or whoever in the next couple days before the next city council meeting.
Okay.
And I also have another gentleman sitting with me, Jason Cannon, who wants to be an alternate member. He's kind of pressed for time sometimes, so he felt he might want to be an alternate, and he would also submit a letter for the city council for the next city council meeting. So anyway, he's here with me now. Jerry Furberg, I think he's having troubles getting on. So just wanted to say that before you got started.
Okay. That's fantastic news.
Okay.
And hopefully.
Can anybody hear me now?
Yes.
We can hear you, Ben.
Woohoo!
You're good.
All right.
Did I miss anything?
No, nothing of import. That's fantastic. And certainly, folks can participate in and hear this call using the Zoom invite. And as we all well know now, we're live streaming and the public can view us as well. So if Jerry or anybody else wants to still be able to view, even if they're having some Zoom issues, I think that's still available for him to view and listen to what we're doing. But I appreciate that, Mr. Chairman. All right, members of the board, at least members of the board as of today, this evening, welcome and thank you for taking some time out of your lives and your evenings to do a little discussion this evening about just some general training issues. I want to say from the outset that this is general, and we just had a meeting, as you know, and a hearing, as you know, and the training we're doing and the discussion and the general sort of things I want to cover tonight are not about any application in particular, not particularly about the last hearing or anybody or any property. These are general sort of training topics that we as a board need to just go over periodically. And I think it has been some time. So while we can draw, and I'm on past real cases, and we can talk about past real cases in a either specifically or generally, I just wanted to make clear to you and anybody out there in the public who may be listening in on what we're doing, we're just talking generally about principles now and not about any particular case. So I gave to Diane just today an outline of the things I wanted to cover. I asked her to give that to you and send that to you board members by email. Again, it was today, realizing that's after your packet deadline and just given to you today, you may not have had, and I do not expect you to have had time to go over that outline. But if you have that, feel free to follow along because that's the document I'll be referring to as well. I wanted you to have also something to take with you after this evening to refer back to. So if there's anything in writing that you have, either tonight or going forward, that you want to ask me about, feel free to do so. So let's start with some very basic information. Who is the Variance Board, this group? Under what authority are you constituted, and very basically, who are you? Who's the Variance Board? You're a 5-member board appointed by the City Council to 4-year overlapping terms, and as Chair Smith alluded to, with a potential alternate who might be interested. You are also, by the city's code, authorized to have 2 alternates. We have no alternates right now. Wish we did, and maybe we would have one if the chair is able to wrangle his acquaintance into applying to be an alternate. Having a full board for the Variance Board is very important for reasons I'll touch upon later. But again, I'll sort of go through this in order. Qualifications to be on the Variance Board are quite simple, simply that you are a resident of the city. What is this board's role? What does this board do? You have 2 main areas of responsibility under the city's code. And those 2 areas of main responsibility are to decide and rule upon variances. The second area of main responsibility is to decide and rule upon appeals. Appeals from what? Appeals from decisions or determinations or interpretations of the CBO, of the chief building official in the city. That latter category, appeals, we don't see very often on variance boards, sometimes called Board of Adjustment in other jurisdictions. The main thing the Variance Board, given your name, is called upon to decide are variances. That's the more common thing you will see. Funny enough, we almost had an appeal queued up as city staff to present to you as recently as about a few weeks ago. That went away because of the determination of the building official changing. But you were almost in position to hear an appeal, and you very well could be someday. So those are your 2 main areas of responsibility. You'll notice, board, that your 2 and sole areas of responsibility are both to conduct hearings on things. And again, I'll go further into this later, but that means you are actually the only board or commission or body in the whole city of Idaho Springs that only does quasi-judicial things. That is your sole responsibility and your sole authority to act, are these quasi-judicial actions. So we'll talk more later about why that's important and what that means for you. You, quite frankly, because of that, will see that you have arguably maybe the hardest task of all city boards and commissions because of that quasi-judicial implication. And I see Diane just put up the outline of the things we're going to cover here. So thank you for that on the screen share. So moving on to under 2 there, the first highlighted issue there, we're going to talk about these 2 main areas of responsibility that you have. And first is variances. So an ISMC in my outline here stands for the Idaho Springs Municipal Code. So under the Idaho Springs Municipal Code, section 21109 sets forth the standards, the legal standards that you as a board are called on to apply to variances. There are 6 criteria that you by law have to apply to variance applications that you are to hear. And I want to talk about those criteria, each one of them, real briefly. I promise I'll be as succinct as I can here, because I know it's a Wednesday evening. You probably have other things that you wish to do. So I'll try to be as efficient as possible here. But before we talk about each of the criteria, I wanted to talk a little bit about why why in the world do you have these 6 criteria that are kind of lengthy in the code? And the reason is when you act as a quasi-judicial body, your role, again, and this is very unique to you as a board, your role is to, as the name implies, quasi-judicial, act like a judge. You are to issue decisions and findings based on the law that is set forth, and you apply it to the facts that are presented to you. Because you're acting like a judge, as you can imagine, like a courtroom, or as you can analogize what you do to a courtroom, there are certain procedural requirements that apply to what you do, and some procedural requirements that we, and it's our obligation as staff to help you with this, to make sure that you follow, so that the integrity of your decision, like a court decision, can be upheld. And that process protects multiple parties' rights to what's called due process under the law. And that involves everybody who is an interested party. That includes the applicant, of course. In the context of variances, that includes neighbors and people kind of in the immediate vicinity of the applicant. All of those folks have, under the law, certain rights to testify, rights to be heard by you, right to question others, what's called cross-examine, the right to present evidence. And importantly for you, the right to be heard by an impartial decision maker, right? Judges, as we know, when cases are heard in a courtroom, are expected to be impartial arbiters of that controversy, of that case. Same is true of you. You're absolutely required by law to be impartial and to not have a preconceived notion of how you're going to rule, and to not have bias, to not have any skin in the game, as it were. And we'll talk a little bit more about that as well in terms of conflicts of interest and what that means. So and this all goes back to the criteria as well. Not only does everybody who has a legal interest in a variance application have the right to certain process, they also have the right to substance, and that goes to the criteria that are in the code. Why we have as a city, and why every city has pretty lengthy criteria, legal criteria to apply to a variance request, is when you, as the decision maker, as the judge, have these concrete objective criteria, you're much less likely to issue a decision based on things that are impermissible, your personal feelings, relationship with the applicant. Maybe it's a family name everybody in the community knows. Maybe it's a property on a prominent corner that everybody knows. Especially in a community the size of Idaho Springs, you may have, as members of this community, some sort of horseback sense of a person or a property. And that's okay. That's to be expected, again, in smaller communities. But the criteria in the code will help you as decision makers not allow that, not allow those issues, not allow your relationships or familiarity with people or property. If you follow the criteria, that will help you as a decision maker base your decision on those legal criteria rather than other things that can't be measured or evaluated. And additionally, the criteria are important because if and when a board bases its decision on the code criteria rather than some sort of nebulous other things, then if your decision is appealed, your decision or your ultimate decision is much more defensible for me as a city attorney to defend whether it's an approval or a denial. If your decision is based on articulated code criteria, it's much easier for me to say, look, judge, these are the criteria that the board was required to apply. And if you look at the record, you'll see board member A referenced this code criteria when she made comments, when they deliberated. You will see Chair Smith noted that he did not think this criteria was met when they were deliberating before they issued their decision. All of that really good stuff on the record that refers to the code criteria helps me articulate to a judge why the judge should uphold your decision and let it stand. And in that context, a final note, I won't go too far into the standard or the legal niceties of what an appeal would look like, but you should know and be aware your decisions are appealable as an initial matter. Your decisions are appealable to district court under Rule 106 of the Rules of Civil Procedure. Again, I won't go too much into it, but suffice it to say, under that rule, the Rule 106, your decisions, just like the decisions of Planning Commission or the City Council, they're given great deference under the law. The law requires a judge to let your decision be, to let it stand, if and when it is supported by some competent evidence on the record. And if you follow the legal criteria that you are required to apply. If there is, it doesn't even have to be overwhelming it. It's not beyond a reasonable doubt. That's the standard everybody knows, right, in the criminal context. On appeal of your decision, a judge is called upon to apply a much, much lower standard than beyond a reasonable doubt. Was the Idaho Springs Variance Board correct beyond a reasonable doubt? We're not even close to that level of review. A judge would be required under Rule 106 under that appeal to let your decision stand if it is supported by a little bit. Some case law have called it a scintilla of evidence, a shred or a scintilla of evidence on the record that supports your decision. So I don't bring that up to say, find as little evidence as you can find to support your decision, but I do want you to be aware, we have to give a reviewing court some basis of your decision that relates to the code criteria. And if you do that, which is proper, your decision will be upheld on appeal, if it is appealed. So it's very important to relate back to the code criteria. So let's talk about those criteria a little bit on the next page, and what those mean kind of in layman's terms. The 6 criteria set forth in Code Section 21109 are as follows. When reviewing a variance, the variance board shall apply these criteria. Number 1, and I won't read it to you because you can read just as well as I can. Basically, the applicant will suffer a hardship, right? What does that mean? In lay person's terms, what's a hardship? Not just an inconvenience, right? Not just, well, gee, it might cost me a little more money, or it's not my preferred way of doing things. It's a true hardship. In addition, you will see that this first criteria relates to the hardship being created by something unique to this property, a unique condition of this property that is not present in other properties in the same district. We in Idaho Springs have, in more than any other community that I represent, currently represent, geological conditions, true unique conditions to property that are somewhat immutable, that can justify a variance, unlike, say, a property on the Eastern Plains or down here in the metro area, where lots are fairly common and have kind of the same grade. There might be floodplain issues down in the metro area or out in the Eastern Plains more than Idaho Springs. But we, as with other mountain communities, really have properties that have true unique conditions. to them based on topography. And those kinds of geological conditions or topographical conditions can really constitute a unique characteristic of property that could constitute a hardship under this first criteria. The second criteria, there are no reasonable design alternatives or alternative locations or for structures that would eliminate or reduce the need for the variance. What does that mean in layperson's terms? That means you as a board are required to look at, hey, are there other ways of skinning this cat that would not require a variance, right? The person who's coming to us, are there alternative reasonable designs that could achieve reasonable use of the property? Now, it's not just that this criteria gives you as a board the obligation to look at alternative ways of skinning the cat. However, it also, this criteria gives you the ability, board members, to look at cost. And maybe there is a way to engineer a projected project in a different way that would not necessitate a setback variance. But if the alternative engineering and design that is possible is, say, $1 million project rather than a $300,000 project, wow, that's a pretty significant increase in cost. And this criteria gives you, board, the ability to look at that cost of the alternative design and say whether or not the extra expense of that other available design is reasonable or unreasonable. So that's all within your purview to consider. Third criteria, the need for the variance does not result from the intentional, reckless, or negligent actions of the applicant or his agent, a violation of any provision of the chapter or the code, or a previously granted variance. What does this criteria mean? Basically that the applicant cannot have created the hardship about which she now complains, right? An applicant cannot illegally construct something and then say, well, because my garage is here that I previously put there, now it's infeasible for me to have a walkway to my front porch unless I violate this side yard setback. The applicant cannot, him or herself, have created the need for the variance. This criteria also makes it clear that variances can't justify other variances. So on the same sort of analogy, let's say someone gets a variance to, because of the unique topography of their lot, let's say someone gets a variance to place a garage in a setback. Because of the variance granting the garage to be located in the setback, now, let's say the property owner says, well, in times of winter, and I've seen this variance, I can't get from my garage to my home, outside the elements unless you give me another variance to exceed lot coverage to construct a tunnel, right, or a walkway that's covered, so it would count against my lot coverage to get to my home. So now I need that variance. This makes clear you can't stack variances on top of one another to sort of justify further and further variances. Finally, this criteria also, and this comes up a lot, makes clear that variances are not justified by a previous violation of the code. And where we see this a lot is the bad actor seller, right? A property owner doesn't get a permit, doesn't ask for permission, and builds something illegally that doesn't conform to the code. All right, let me turn off my phone. Then poor unsuspecting seller, right, purchases the property with this condition that was, it's a code violation, but poor unsuspecting buyer buys the property, and then for whatever reason, whether it's a complaint or just doing the right thing and the seller mentioning it to somebody at City Hall, but it comes to our attention that the structure does not meet code. Well, the new owner of the property may very well say, hey, I need a variance for this. And this is a hardship on me and I didn't create it. Unfortunately, a variance cannot be justified by a violation of the code. And it's true, caveat emptor, buyer beware, do your due diligence when you're purchasing a property. Drew probably knows this very well, being in real estate, right? So variances are not to be justified by unlawful acts. The fourth variance criteria, reasonable protections are afforded to adjacent properties. Basically, board, you are being asked to decide in a variance, among other things, how is this going to affect neighboring properties? If we allow a setback for, let's say, or a setback, if we allow a variance, let's say, for a height limitation, maybe because of the unique conditions of a property, if we allow a structure on this property to be higher than usual, how's that going to affect the solar exposure for their neighbor, right? And to the north in particular, maybe. How is this going to affect the sunlight this property is afforded? Or how is it going to affect their enjoyment, their air, the circulation of light? If we allow a setback variance on this side yard, how close is that other property? How will this affect them as well? So you're absolutely called upon to evaluate how a requested variance will affect others in the immediate area. Fifth criteria, the variance is the minimum variance that will make possible the reasonable use of the land. Rather than taking a mile, maybe the person needs an inch, right? Requesting a variance to, let's say, that height limitation because of the topography of my land, and I can't have a usable single family home without a 10-foot height variance. Well, the city's engineer may look at what I've submitted as the variant applicant and say, this will really work with a 5-foot. It could meet code and have the minimum height per story, per habitable story, and still have usable space with a 5-foot variance instead of the 10-foot requested variance. So you are called upon to evaluate the extent, the scope of the variance that's requested too, and to grant it only to the minimum amount that's necessary, in your view. The last variance criteria, the granting of the variance will observe the spirit of the chapter, secure the public safety and welfare, and ensure that substantial justice is done. Admittedly, that's sort of the fuzziest of these criteria for you. This criteria requires you to really look at the whole of the zoning code and the neighborhood, right? And the effects of the requested variance on the area, and evaluate that kind of holistically. And quite frankly, to evaluate if that's fair or not, the requested variance. So those are the 6 criteria real quickly, and what sort of they mean in I think more lay terms than maybe what the code sets out. A couple of additional practical points on variances. The code does not authorize you as a board to consider, evaluate, or grant what are called use variances. And that means the uses that are set forth in the zoning code for particular districts, right? You can't alter those. And someone can't come to you and ask to alter those. That would essentially be rezoning the property, right, to allow different uses. Like, let's say we're in R1 and I'm a homeowner in R1. and I come to you and I say, you know, I got a really big lot, I got lots of space, and I really need to make some money. So I would like to do a triplex. Shoot, let's do a multi-family. I want to do 5 units, and I've got a big enough lot to do it. So I want you, board. And you know, let's say I'm on R1 and I border commercial, so it's really no big deal. So I want you, variance board, to grant me the ability in my R1 lot to do multifamily. Code says no. You don't have the authority to grant use variances. You only have the authority to grant variances to building standards, right? To the parameters of the lot or to the parameters of the structure that is sought to be built. And that's very common, actually, in zoning criteria or in zoning codes across jurisdictions. Use variances are not typically okay or granted. Another practical point on variances, and these are in the code, the endorsement of the variance request by neighbors doesn't eliminate the need to follow the criteria. So please do keep that in mind. You could have a variance applicant come in, and everybody who they bring in with them, and every neighbor may say, love it, we love it, don't care, we're on board. That does not eliminate the need, board, for you to still go through those 6 criteria and evaluate the application on the merits of it. It does not matter. And this goes to justice is blind, right? It shouldn't matter if someone has a bunch of friends or gets along great with their neighbors, if the law says these are the criteria for which you can get a variance, right? Every variance shall run with the land, but shall apply only to the specific building or structure for which it was originally sought. This goes to kind of to the issue of nonconformity, but like a nonconforming structure, which variances are, but like a nonconforming structure that's created by the passage of time, variances are the same in that they're really meant to apply just to that particular structure, that house, that garage, that shed, that structure for which a variance is sought. The variance is good for that. Once that structure goes away for whatever reason, the variance goes away as well. So these are intended to be extraordinary remedies and not permanent forever and ever amen remedies, unless you have a really well-built structure. The granting of a variance shall not constitute or be construed as precedent for other variances. That's also important, and I want you to keep in mind that as well. Hold on, Drew. I see you. Let's say you have even neighboring properties who come to you with really similar requests for a setback for, let's say, a garage. Granting one variance for one neighbor does not bind you or legally require you to grant a very similar request from another property owner. Why? Each property is different. Each property is unique. Going back to the first criteria, right? You are required to evaluate, and more importantly, every applicant has the burden, and it's the applicant's burden to prove that his or her particular unique property justifies the variance. So when you think about it, that makes sense, right? That just because it might be also a setback request for a garage, hey, this person's property is not exactly the same as this person's property. And you as a board have the ability, and you should, look at each application absolutely on its merits. Just like, again, hearkening back to the judge example, every defendant in a criminal courtroom has to be judged on her or his behavior, not everybody else's. Let's put aside conspiracies, right? or other kinds of theories of criminal culpability. But every person should be judged on their own merits. Same thing for you and properties. Drew, did you have a question?
Right. I do. I just want to make sure that I understand from a real estate standpoint, the point about it running with the property, but for the individual structure. So if there is an empty lot and the owner has gone through the process of variance to have setbacks changed, and then their life situation changes and they need to sell the property, those variances will travel with the land as long as it's the exact same structure that they got approval for. They can't change anything. But if the person that buys it wants to do a different kind of house, a different design, would they have to go back through the variances process?
Good
Or
question.
is it just house?
Yeah, only if whatever the new owner of the house wants to do also requires a variance. In other words, let's say, in your example, they want to pop the top. If popping the top requires a height variance, they would need to come in and get it. If popping the top does not require a height variance, no.
Okay, so it could be any house. It doesn't have to be the specific design that we offered a variance for, because we don't get into the design process.
Right.
We're just talking about the size of the
Exactly.
Okay.
Exactly. Yep. I think you're thinking about it the right way. Yep. If
Okay,
whatever yeah, go ahead.
So our job is if an individual buys the house that have a previous variance on it, bought the house and wants to renovate the house and change a variance, that's where we come in. Now, technically, and correct me if I'm wrong, the person that buys that house and knowingly knows that it's not in compliance and then asks for a variance should not be granted a variance. But that's hard. That's hard to, know that that person's intent was doing that. I mean, we will have some variances, Drew, that people buy stuff that probably should have talked to us or asked for the variance before they bought the property.
Yep.
And we have to determine whether their intent once they bought the property was purposefully knowing that it was not in variance and did it anyway, or whether they did it and not knowing the codes. So we'll have those situations, and we've had those before. So
That's why realtors have errors and omissions insurance.
well, we are the last say in the errors and omissions, I guess, right?
Yeah, I mean, because
Okay.
honestly, if I sell my client a property and I have not informed them,
Yep.
that really does come back on me. Or
Okay,
would.
so now you have to tell them to go get a variance before you sell something, because
Right,
They
well,
should.
yeah, I mean,
or
I
and-
would find it hard to believe that a realtor wouldn't do their due diligence, but it happens.
I have two topics that I would like to talk about, and one is excluding ourselves from certain variance board meetings based on not having. Help me, Cameron. I went blank.
I'm gonna address conflicts of interest. Is that what you want?
Conflict of interest. Thank you.
Yep.
And the other one I want to talk about tonight is procedures. So.
Yeah. Okay.
Okay.
I'll
give it back to you.
Okay, no sweat. So let's see, other final practical point on variances, they're basically, and we covered this a little bit at our last hearing because it came up, it was germane to the discussion, but variances are generally effective for a year. And that's a time period during which the applicant has to pull a building permit. Not even complete the thing, but just obtain a building permit. So you got a year sort of to get your ducks in a row after you get a variance to pull a permit to even begin to construct the thing. That can be extended, that 1 year period, one time by the city administrator. You have to show some good cause and demonstrate that there won't be harm. So that's the last practical point I wanted to make on variances. And then You'll note in the outline 3 basic choices on variances: approve it with conditions, or deny it. Those are the 3 basic doors on variances. On appeals, I'll pretty quickly cover appeals because, again, we don't, you don't see a lot of appeals, but the code does authorize you to hear and decide appeals from, again, decisions of the CBO, the chief building official, or really anybody who is called upon to interpret the city's zoning code. Sometimes that could be community development, it could be a planner. More typically, it's Safe Built, our building folks. But when you are called upon to hear and decide an appeal, the code requires you to decide that by evaluating whether or not the city staff acted, 1, without clear and convincing evidence to support their interpretation or their ruling, or 2, the building official whose decision is being appealed acted outside of his or her authority. So those are the legal, again, criteria for appeals. As the case with variances, board members, you don't have to commit these to memory. We as staff, it's incumbent upon us and our planners to help you through staff reports and your packets navigate these criteria and these legal standards on each case as they come before you. Actions on appeals, much like actions on variances, have 3 basic choices for you. Affirm the decision, uphold the decision, reverse the city staff person's decision, or modify it. And also you can combine those things. Maybe you affirm part of it and reverse part of it. Maybe you modify part of it while reversing and dumping another part of it, right? So you can really on appeal make the decision match what you think it legally needed to be. Moving right along, because I know we're chugging on towards close to an hour here, but how do you do what you do? Public meetings, right? Just like the one we're in right now, this meeting is viewable and open to the public. If we weren't in the throes of a global pandemic, we would be at City Hall right now doing this all in the same room, and people could come and sit there with us in council chambers and watch and hear what we're doing. You, like every other board and commission, just like city council, are subject to the Colorado open meetings law, what's called the Sunshine Law. Just for your purposes, know that your meetings are public. They always will be. Under the law, they must be. We as staff, it's our obligation to make sure we properly notice your meetings. That's on us, not you. I will give you the one little practical note here on the bottom. The Sunshine Law applies to either 3 or a quorum. For you, that's the same number, right? For council, for instance, 3 is less than a quorum for them, but for you, it's the same. So 3 of you, again, all living and existing in the city of Idaho Springs, may run into each other from time to time. You may know each other offline, and that's okay. The Sunshine Law and you serving on this board does not mean that you have to avoid each other now for your 4 years on the board, because the Sunshine Law specifically says that the requirement that when 3 of you get together, the public can attend, it doesn't apply, let's say, to your kid's birthday party or a PTA meeting or a sporting event or any other reason, or church. If you all are members, if 3 of you are members of the same congregation, the Sunshine Law specifically says, hey, those kinds of gatherings of 3 of you or more are not meetings under the law. However, of course, I caution you, if the 3 of you are somewhere, you find yourself somewhere together, just refrain from discussing city business, right? And certainly refrain from discussing a pending case outside of the context of a public meeting. So your meetings are open to the public. And a little note here, I had a little note for myself at the end to cover this, but it sort of makes sense here, so I'll cover it real briefly. I encourage you to keep in mind this public and open feature of all your meetings, even in this day and age of Zoom meetings. I know I'm in my office, but I do a lot of these from my home as well. Some of you may be at home, all of you may be at home, I don't know, right now. And I encourage you, even while at home, treat these meetings, whether your camera's on or off, but especially when on, like you would if we were in council chambers. And I'm honestly, I swear and affirm, I'm not using an Idaho Springs example here, but I have been on Zoom meetings in other jurisdictions where folks, the decision makers, officials, government officials, have seemingly forgot that the world and everybody is watching what they're doing, just like they would be watching what they're doing if they were up at the dais in council chambers. Folks are having 3-course meals. I haven't seen shaving or anything that blatant, but please do remember these meetings are open to the public, and the public can view you just as they would in person. So these meetings are, I think, entitled to the same decorum and respect that they're typically conducted in person, even on Zoom. Keep that in mind. And again, I'm not calling any Idaho Springs in particular examples of things I just noted. I think as this current state of virtual meetings for everybody across the nation and certainly Colorado, as that continues, I've seen that people have become a little more comfortable and maybe a little too comfortable with the virtual platforms, and they sort of forget, hey, I'm an official here. I'm a local government official, and I'm going to give this meeting my attention and decorum and respect that I would in person. So I encourage you to keep that in mind. Let's next delve into the difference between a public meeting, which I just sort of briefly covered, right? That means that we notice it. A public meeting, people can watch. There may be a million eyeballs on us right now, who knows? That's a public meeting. In contrast, a public hearing is something that happens within a public meeting. And again, a public hearing is a quasi-judicial, because it's a hearing, is a quasi-judicial animal and a quasi-judicial proceeding, and almost exclusively what you folks do as a variance board. You will almost always, tonight notwithstanding, you will almost always be doing hearings, right? So this stuff is super important for you. Quasi-judicial proceedings. How a public hearing is different than a public meeting is the public hearing is the portion of the meeting during which you accept evidence and testimony on a particular application and then deliberate and decide on that application. You are acting as a judge, a jury, the fact finder, and the decision maker in quasi-judicial proceedings. And again, you're unique in this way. You don't act legislatively like the council does. City council sometimes has quasi-judicial hearings, like when they have liquor license applications, right? Or when a final development plan, a site plan, when that finally makes its way up to council, council has its own hearing, and they're having a quasi-judicial proceeding. Council also a lot of times talks about legislative issues. They adopt ordinances, they adopt laws, and those are not quasi-judicial proceedings, right? Who cares? And why are we talking about this? It's important to know the distinction because of the procedural implications as well as the substantive implications for you. I've included a little excerpt from case law there about what the difference is between legislative and quasi-judicial actions. I won't even go through that word by word because you as a board don't have to sort of toggle back and forth, right? So you don't have to sort of make these conscious decisions on what kind of action you're engaging in. You're almost always engaged in quasi-judicial. So why does that matter? There are a certain number of requirements there. Why does it matter what kind of action you're taking? One, when you take quasi-judicial action, notice is required. We as staff take care of that. A hearing is required. The right to present witnesses and evidence is required. The right to legal argument is guaranteed. The right to appeal is guaranteed by law. And no ex parte contacts are allowed. And I'll talk more about that. So the typical steps of a public hearing, again, the notice and hearing are required if you're doing quasi-judicial. So what are the typical steps of a public hearing? Testimony and evidence from city staff is usually first. Here's to your point, Chair Smith, on process. Open up the public hearing. You typically have testimony and evidence from city staff, then testimony and evidence from the applicant. You as commissioners or board members can ask questions after each of those folks go. There should be a public portion in here. That's my error, I apologize. The public has the right also to present testimony and evidence. After everybody has provided their testimony and evidence and you have asked all your questions, you can close the hearing part of that proceeding. And what that means is you, again, have received all the evidence and testimony that you require, that you want. You've asked all your questions of the applicant, of city staff. Now, let me also say, after you close the hearing, if you have a question about process or anything like that for me or a representative from the city attorney's office, you can still ask about process and things like that. Well, how do we do that? Can we make a motion to do this? And what does this vote mean? Those procedural questions are still okay. Before you close the hearing, you should have all your substantive questions answered. Like, is there really, how close is this neighboring property to this one? Staff, can you tell me? Your applicant, how much did you look into the cost of this or that? Those kinds of questions should be answered, and you should have all the evidence that you require before you close the public hearing part of the proceeding. Then what do? Just like a judge, right? When the trial is over and closing arguments are done, or maybe this is more intuitive for people, much like a jury, now you deliberate. The only thing is, board members, unlike a jury who usually goes off into their jury room to do their deliberations behind closed doors, you, as a decision maker, you're supposed to do all that talking amongst yourselves and all that visiting and all that deliberation on the record, in front of the applicant, in front of the public, in front of everybody. And I will say there's an allowance if you need legal advice while you're deliberating. We can call you can call what is called an executive session if you need some legal advice on something. Or if I feel that I need to tell you something that's confidential and privileged in terms of legal advice. A lot of times I will answer your questions legally or procedurally, no big secret, nothing confidential there. But if and when you're deliberating amongst yourselves and you have a legal question, we can go into executive session. But that aside, again, you are supposed to talk to each other like a jury would in a jury room about, I was really persuaded by this, and this piece of evidence. Or, you know what? I didn't believe that this criteria and this criteria were met, my fellow board members. How do you feel? You as a fellow board member should respond and say, I agree or I don't. And what that does when you deliberate like that, why I say you should do that on the record, is that helps explain your decision once you make it. explain how you got there. And remember what we talked about first? It'll help you explain why you're deciding what you decide ultimately in relation to the code criteria. Keep coming back to the code criteria. That's why I said you may say, well, I was persuaded that this criteria and this criteria were or were not met. That establishes a great record for the decision that ties your decision to the code criteria. And that makes the decision defensible if it's appealed. Again, I also think it goes really far in helping people understand why you decided the way that you decided and that it was based on the code. So once you've done that deliberation like a jury, then you issue your decision. Or as you can see, you might continue the matter if you need some more time to think about it. So that's a real quick rundown. Chair Smith, did you have any other questions or things you wanted to touch upon in particular about process before I go into ex parte contacts, or anybody? Do you have any questions about the hearing process itself?
Okay, so first of all, you're doing a very good job explaining all this, especially on the process. Last meeting, and I apologize, it was my first time, but it was a lot of our first times, but
Sure, it's okay.
I really think, and the procedure part of the meetings, we should adhere to, and I am all for asking questions. I'm all for getting to any issues that any of our board members have. However, I think it's very important that we listen to the city's review and then actually listen to the testimony of the individual that is presenting the variance, because those two statements from each may have conflicting information, may have the same information, may consolidate our thoughts, or it may just bring up more questions. What I would like to see going on in the future is for us to listen to both the city and then the witness, and then come up with, write down the questions as they're talking. And then once that happens in our question period, consolidate our questions and direct them to whoever that we may have that question for. That way, it's the procedure I would think would be better for us to be able to ask more detailed and in-depth questions of whoever we may choose to ask a question to. So that was a little bit of my issue from last meeting that we had. All the questions were good. Like I said, it was my first time as chairman. I didn't quite know how to direct the meeting. But in the future, I would really like to see us be more organized, more professional in how we handle ourselves as a board. I think we kind of got a little quagmire, and I would like to see us perform more as a united kind of board. And I know we're not always going to agree as a consolidated board, but that's okay as long as our procedures are professional and we proceed that way. That was my statement on the procedures part of it. So.
Yeah, Chair Smith, I think good points all around. You hit the nail on the head there. Y'all can disagree 6 ways from Sunday. If you follow the proper procedure, we can defend, and I can defend any outcome if you follow the proper process. And Chair Smith, I will take as staff some responsibility as well for helping things go more smoothly in the future. I want to sort of cover, this evening, not only some basics in the law, but process for the whole board, but for you as chair and anybody who may become chair in the future, I will, take some ownership of failing to give you a really good roadmap before the last hearing. And we'll do that for future hearings.
It's not all your fault, Cameron, because I told Diane I was going to come visit her and sit down with her for about 15 minutes and let her tell me the procedures.
Yep. And you know what? Yeah. We'll have something like sort of like a roadmap or a script for you at the next and subsequent hearings, Chair. So rest assured, we're all in this boat together.
Okay.
All right, very good. So ex parte contacts was the next issue I wanted to talk about, because that will also come about a lot in a smaller community, and is very important for quasi-judicial proceedings for you as a board to understand what they are, ex parte contacts, and what they mean. Because remember, when I talked about why does it matter if something's quasi-judicial, one of the reasons why it matters is we can't have ex parte contacts with quasi-judicial proceedings. Well, what the heck are those things? Why do we care? An ex parte contact is defined as a contact between the applicant or opponents and the members of the public body, that's you, outside of the publicly scheduled hearing or meeting on a quasi-judicial matter. So a contact between the applicant or the opponent and you folks outside of the hearing. An important thing to know then is, when is something a quasi-judicial proceeding? And for variance applications, it's less fuzzy than it sometimes is for planning commission and city council for things like maybe a potential project, a potential site plan, a potential FDP, a potential application. I might want to rezone my property. Those things can be talked about quite a bit before they actually become ripe under the law. Variance applications are people decide they're going to do it and they submit an application to do it. But board members just know that the magic moment in time when a matter becomes at issue, or like I said, ripe, analogizing to a legal case, is when an application is actually submitted and received by the city. At that point, when an application for a variance is submitted, it's live, as it were, and ex parte contacts are now legally impermissible. And again, that's a contact from the applicant or an opponent, say a neighbor who's against the variance. Those folks talking to you outside of the hearing cannot occur. Why? Why are those contacts to be avoided? If there is some evidence, an allegation on appeal that an ex parte contact did in fact occur and we haven't dealt with it, and I'll talk about how to deal with it. But if there's evidence on appeal that an ex parte contact occurred and it impermissibly influenced the decision, the consequence could be as severe as invalidating the decision. Whether or not the one person who had the ex parte contact was a deciding vote. Let's say it was unanimous. Let's say we get all 5 members on board, it's 5-0 to grant the variance, and an opponent appeals because one of you had an ex parte contact with the applicant. It doesn't matter what the vote was, it could invalidate the whole enchilada. The whole decision could be invalidated if an ex parte contact occurred and impermissibly influenced the decision. Why are these such a big deal? Again, going back to due process and those procedural guidelines, those rights to be protected that everybody has, the applicant and the opponent, maybe, if there are any. They have those rights to the neutral slate, the unbiased judge, right? The judge that comes into the hearing not having made up his or her mind and basing his or her decision only on the things that are presented at the hearing. The other party, right? Let's say it is the applicant, reaches out to you and talks to you about an application off the record, outside of the hearing. That deprives the other party, any opponents, the opportunity to hear what the applicant is saying to you and to respond to it, right? To effectively rebut that out of the hearing testimony. Let's say it's an opponent. Maybe this makes it more concrete, but let's say it's an opponent to a variance and who reaches out to you and says, I just disagree and let me tell you why. Well, the applicant clearly is being harmed if you engage in that kind of communication with an opponent of their application, like off the record. Another reason why those ex parte contacts are to be avoided is it doesn't become part of the record. How much that influences you, for right or for wrong, is not measured and cannot be measured on appeal. Also, all your fellow board members don't get the benefit of maybe a really good piece of information, right? The other 4 members of you, again, when we're full up and we're a 5-member board, the other 4 members don't get the benefit of that testimony. And just flat out, simply they're unfair, right? For all the aforementioned reasons, it's very much like a judge going to the country club and having a cigar or a scotch or a milkshake in a good old rated, G fashion with the prosecutor, but not the defense, or the defense, not the prosecutor. A judge can't do that. You can't do that either with either side of a case outside of the presence of the other party and outside of the hearing. So how do you avoid these things if, let's say, a neighbor or an applicant, knowing full well who you are in the city of Idaho Springs, this may be someday your neighbor or someone who your kids are, as a parent, your kids are friends, right? Or you go to the same church, or maybe you're in the chamber together, or who knows. But someday an applicant could very well be someone you know. And what if that person who knows you well thinks, you know what, I'm gonna call up Ben because we're buddies, and give him my I don't really want to go to the hearing, but I really want to share my view. So I'm just gonna call Ben up. What do you do if that happens? Unfortunately, you have to do your best to cut off that communication once and if it begins. And if somebody whom you know, who may be your friend, right, or even a casual acquaintance, but who you know, wants to talk to you and they begin to do that, what do you do if they say something and you can't unhear it? You can't unring a bell, right? Cut them off as quickly as you can and say, hey, I'm sorry. I cannot listen to that outside of the hearing. Please come to the hearing. Well, I don't want to. I can't. Well, I'm sorry. I can't hear your evidence. Would you like to submit something in writing? You ask Diane. We have people very frequently in quasi-judicial hearings before council or planning commission, and it could be in front of you as well, say, I cannot make it, or I don't have this technology to testify. Can I send you an email? Yes, and you can. And what we'll do with that then is bring that email and give it to everybody, including the other side, right? If it's the applicant or someone who's pro-applicant, we'll present it in the hearing so that anybody who's in opposition can hear it and address it. Like I said, have the opportunity to rebut it. If someone begins to have an ex parte communication with you, whether it's in writing or in person or over the phone or over FaceTime, do your best, board members, to stop that person and say, hey, I can't hear this outside of the hearing and the presence of my fellow board members and everybody. So please come and share what you want to tell me at the hearing. I can't. Please put that in writing and send it to the city clerk, and she'll make sure that it gets put into evidence and into the record at the hearing. So that's the way to deal with an ex parte contact. If one starts and you can't stop it, just do your best and be real forthcoming, because we can deal with those things if we know about them as staff, and we can get them in the hearing in the proper way. If you, let's see, other common questions, sorry, about ex parte communications and what you can do outside of a hearing. Some common questions that I have encountered over the years of doing this with different bodies. Sometimes board or commission and council members want to know, well, can I do my own research on a topic outside of the hearing? While that sounds like a really responsible thing to do, in the context of a quasi-judicial hearing, it's usually not a great idea, simply because of what I've just explained. The reasons for your decision should be on the record and in the hearing, so that everybody gets the same information, not just you on the internet at 10 o'clock at night, right? Everybody needs to get the same information. You, your fellow board members, and the applicant, and any opponents. So if you really want to know something, you have something you know is going to be germane, is going to be relevant to a particular hearing, because you've looked at the packet, and you really want to know a piece of information. Let the hearing happen, I encourage you to do this. Let the hearing occur. Maybe the applicant is going to testify about the very thing you want to know about, or another interested party is going to testify about the very thing you want to know about. Let's say everybody testifies and we get to the end of the hearing when people are done saying what they want to say, and you still want to know something, right? And nobody's testified about it. At that point in time, when Mr. Chair says, any other questions from the board before we close the hearing? Raise your hand. Mr. Chair, I would like some additional information and research and some additional data, whatever it is, on XYZ before I can feel ready and informed enough to make a decision on this matter. Okay, great. You always have that option, board members. You're not limited, right? Just like a judge who hears all the evidence and testimony says, you know, I need some more evidence on this topic. Lawyers, go brief me this issue. Go do some research and come back to me on this. I am going to continue this hearing, this trial, until I get that additional information from you. You can do the same thing. So I encourage you, board, if you have a real hankering for some information or some issue to be fleshed out, that no one does it for you at the hearing, tell us to, whether it's a staff that should do it or whether it's the applicant that should do it. We'll figure that out when you ask for that information at the hearing. Drew, did I answer your question kind of?
Yeah, that was a question I had asked Diane prior to the last session. I had a question about something in the packet, and I had asked if I could reach out to the person that wrote the letter. Right. And she suggested that I talk to the city manager. So I sent a note. They didn't respond, so I did not reach out, just to be clear. Good. But that person did not attend the hearing and therefore didn't answer my question. And so I feel like now, knowing this, at that point I probably would have continued it rather than responded as I did, because from the lack of information, I came to a conclusion based on the lack of information, not knowing that I was able to request more information.
Okay, great. Hey.
Yeah. But now I know.
Good. Yeah, this is all for learning. It's good. So to affirm that and underscore, if any of you board members come to an end of a hearing and think, I really want to know more about this. And let me make clear, I'm not saying that I'm not encouraging you to just kick the can down the road because it's a hard decision and one you kind of don't want to make, right? but I am encouraging you to feel free to ask for more evidence and testimony that's different or additional, right? That adds to
Cameron.
what you've already gotten. Right.
Let me ask you something, Cameron. So if that comes to tuition, if say Drew has an issue with wanting more information, or one of the other board members, and is it possible for us to, I know you gave us 3 criteria, approve with conditions, or not approve. Can we approve with the condition that whatever the question or whatever the board member has for additional information? So for instance, if, okay, if I get this information, I'm going to approve it. If I don't get the information, or if the information I get is based on this fact, I'll approve it tonight. But if it turns out that we don't get that information, or that information is not based on the fact, or does not prove the fact that she's wanting or he's wanting, it's not approved. We can't really do that. Or can we continue the variance meeting and allow for additional time for another? So if we're going to meet every 3rd Wednesday, can we as a group say, okay, yeah, we're all a little stumped, we all want a little more information, or one of the board members does, and we agree with that board member, can we postpone that variance to the following month? Is that something legitimate?
Yes.
Okay.
And again, it is continuing the hearing. That's absolutely an option that you have to get more information. And maybe I could help sort of flesh this out with a theoretical example. Let's say in evaluating a variance, you do not feel, harkening back to the criteria that you have to apply, right? Look at those. Let's say you as a board, or more than a few board members, feel that they don't have enough information to evaluate whether or not there are any reasonable design alternatives to the design that has been proposed, right? Criteria number 2 right there. What if you feel like, we don't have enough information to evaluate whether or not that criteria is met? So we want some, we would like city engineer or the applicant's engineer or architect to provide further analysis and information about why there are no other reasonable design alternatives. Someone who's an expert in this field. And we want not only the applicant's engineer to give us more information on that, but the city's engineer as well. We need that information to make a decision. That's a good example of requiring additional evidence and testimony that you don't have, that you feel you need. That would be a good reason to continue the hearing to another date, to the next meeting date, Mr. Chairman. In contrast, and to your point, Chair, about, well, could we conditionally approve? Sometimes we do, and you'll see examples of this with City Council recently I can think of. Approval of, let's say, approval of a site plan or a proposed development on the condition of the city engineer approving the design of this feature of the development, or the city attorney signing off on the final version of the annexation agreement in the case of an annexation. That's not new evidence that you as a board want or need to evaluate the criteria you're supposed to apply. That is more in the world of making sure that the applicant checks the boxes with the appropriate city staff who are the watchdogs on certain issues, right? So those are maybe some concrete examples of when you might conditionally approve an application or continue the hearing because you folks need more information on the criteria you're supposed to apply. Good questions. The practical questions. Sorry, Diane, you're scrolling. I already addressed what to do if an ex parte contact has occurred. You can't unring the bell. We don't want you to just tell us if you've gotten an ex parte communication, and we'll deal with it, like, as I mentioned, bringing it into the hearing. Another common question I get about, is this like ex parte or not? Are site visits okay? Really common question. Yes, they are, if a few things are kept in mind. One, if you go, and again, if we're talking about maybe a residential variance, it could very well be that this is not vacant property, right? That the person who is requesting a variance may live there or work there if it's a business already. These aren't all residential variance requests we get. We get commercial variances as well. If you go out to eyeball a property for yourself, that's fine. Take care, please, not to talk to the applicant. The homeowner may come out and say, hey, let me show you. What, come out? No. As I said, if ex parte contacts begin, cut them off as soon as you can and say, hey, I'm sorry, I just wanted to drive by and look back there. I cannot talk to you. I'll come back maybe later if you're not here. Or do whatever you need to do to not have communications and ex parte contacts on a site visit, right? That's the only thing I want you to be mindful of. Why a site visit is okay is that's something everybody can observe with their eyeballs. It's condition of a property, right? That we can't bring into a hearing, right? It's something that is incapable of being presented in a courtroom, in a Zoom meeting or a virtual meeting or at the dais. So that is just an observable reality that anybody can see with their eyeballs, that you can as well, board members. That's why that's okay, and that's not outside research. It's observing what is reality, the condition of the land. Is contact with staff okay? That's another common question. Drew, you reached out to Diane about the packet? Perfectly fine. That's okay. Now, you did the right thing, it sounds like to me, which is, hey, I have a question about what's in my packet. Absolutely, you can reach out and ask a question about something that's in there. In contrast, like what you should not do, and what you knew this sort of instinctually, whether you knew it or not, Drew, was you shouldn't go into the substance of things off the record. You shouldn't reach out to the planner. You shouldn't reach out to Mike and say, Mike, I need you to explain page 2 of your staff report where you say XYZ. I need you to explain that to me. First of all, Mike will know enough to say, ask me that again on Wednesday night.
Cameron,
and that's when you should ask him that, right?
Cameron,
Yeah.
I don't want to interrupt you, but I've been doing this a long time. I understand a lot of this. Is it okay for board members to contact me and we have a powwow about the interpretation of what the city has put in the packet?
No.
That's not okay either?
No.
Oh, so before the board, we should not even contact each other about that?
Correct.
Okay, I just want to clarify that because I understand a lot of it. Site visits. I've 2 years I've been on. I've been to every site.
Yep.
Before, never talked to anybody, but I've been to every site. So okay, I didn't see how that would be a conflict, but if you say it is, then it is.
Well, it's, and I'll tell you, it's not a conflict, and it's not ex parte, right?
Because it's board members talking about what we're going to talk about anyway.
Correct.
We're just clarifying amongst the board what our interpretation is of what the city's packet says.
Right.
So are you're positive that's a conflict?
It's not a conflict.
Okay.
What it is, it's when you think about it like this, Doug, it's like, again, the jury starting to deliberate.
Okay. If you put it, I got it. All right. I got
Okay,
it. Okay.
good.
All right.
Right? So
Yeah,
the applicant, go ahead,
It's a
Mike.
case of where the other board, if two members talk to each other, similar to what Carmen mentioned earlier, is the other members of the board don't have the benefit of that conversation. So they have information that not everyone has. And it's important that everyone have the same information at the hearing. And
Okay. So I was just checking as the chairman, if I had knowledge of what I knew to be on something, could I share it with my board? But if you're saying I can't, I won't. Okay.
Well, hold on, Doug. You can at the hearing. Yep.
Well, yeah. Okay. I got that. Yeah.
Okay.
Yeah. When you said jury, it popped in my head. Okay.
Awesome.
All right. Got it.
May I ask a question? Could I have made a request through Diane, or I suppose Diane? Could I have made a request to have an author of a submitted document attend the meeting? Could I have made that request prior to the meeting so that they could offer more information in order to avoid a continuance?
Yep.
So can I say something though, Drew? And you know how this goes. If it's an engineer or an architect or a general contractor, you may be putting undue cost on the witness that you can't put on. So he may, I guess, how does that work, Cameron? Because I mean, if I was an engineer and somebody that was in front of the variance, a witness, asked me to attend on a Wednesday night, sit there for an hour, and I'm charging them $175 an hour, and I expect the witness to pay me, and the witness says no, how does that work?
Yeah. Well, the good question. You can absolutely, to Drew's question, you can absolutely reach out and ask the clerk to ask someone to attend. That doesn't mean they have to. Now, oh boy, I'd have to look at your subpoena powers, right, to see if you could compel somebody to attend. But generally speaking, chair, members of the board, you can invite somebody and ask somebody to come, including any experts or consultants they may have, but that's ultimately up to them.
Could you ask a written question and ask for a clarification in writing that would be presented at the meeting?
You could do that as well. Sure. And again, the important thing, I guess, or the important guideline here is if you are, sort of asking for either procedural things like people to come, or if you're asking for things to be submitted and then put on the evidence for everybody to get and everybody to know, that's okay. That's okay stuff to ask for. Again, in contrast with talking substance offline, talking about the merits offline. So communications with staff are absolutely okay. Real briefly, and I know we've been going for a while here now, but I do want to cover a little bit conflicts of interest and some ethical considerations. Conflicts, you even though you are appointed officials and you're not elected, you are governed by the same sort of ethical rules and standards of conduct under state law as elected officials are. And I put the CRS site here in case you're interested. But there are more than this, some rules of conduct and ethical considerations that are less mandatory than rules in the part of the statute, if you ever care to poke around. But among other things, what the state statute on conflicts or rules of conduct for local government officials in particular requires is it prohibits local government officials from performing an official act directly and substantially affecting to its economic benefit a business or other undertaking in which he or she either has a substantial financial interest or is engaged as counsel, consultant, representative, or agent. Googly goggly legalese, what does that mean? You shouldn't be an applicant, right? You shouldn't be voting on something that you will financially benefit from. Whether you're the property owner or a partner of a property that benefited, you will see, and the public has seen recently and for the last several months, if not years, a council member, Councilmember Boland, regularly recuses himself and leaves the room and leaves the virtual Zoom meetings, whatever, anything about the Argo properties in front of city council. Why? He's a partner in Argo, and he will financially benefit from a vote on that, on their proposed development. So he knows this rule and properly excludes himself from those proceedings. That's a real life example of a conflict of interest like this. I also want to take note of the last clause here. Even if you're not the owner of the property or a part owner or partner of a corporate owner, you should not be voting, cannot vote on something if you are engaged by the applicant as counsel, consultant, representative, or agent. Let's say, Drew, you work in real estate. If you are helping somebody, right, who is before this board, clearly you should not be voting on that. You know that. But sometimes I find, particularly in smaller communities, this comes up and it's frustrating for members of boards and commissions who are architects, who are engineers, surveyors, that in another community. Look, you can still engage in your livelihood and your business. Just know that sometimes you'll have to make a choice of maybe accepting a client in your own private business world, knowing that you then might not be able to sit on this board, right? If it comes before the board, or give up a job if you really are so devoted to the Idaho Springs Variance Board that this is your top priority. And that may be true for you. And also to the point of alternates, yay. Hopefully we get some alternate members of this board after we get 5, so that if any of you are someday in the position of having to step away from an application because of your own personal business pursuits, we could still be full up as a board. That's our goal, was to have some alternates who could fill in.
Carmen,
Yes.
it might be good to mention the Governmental Immunity Act in terms of how that affects the board members. In terms of having, it's one of the reasons why the procedure has to be properly followed. Otherwise, you run afoul of being covered by the Governmental Immunity Act.
Okay. Generally speaking, that's sort of a little bit tangential, but I'll mention it because the Governmental Immunity Act provides immunity for or against claims that are generally torts, which isn't really directly related to what this board does, but generally speaking, government actors are protected for claims, again, tort claims, claims of negligence or improper behavior, if and when the board member or employee or government actor acts within the scope of their duties and authority. So what Mike is alluding to is, if you act outside of your role as a board member or improperly, right, and allegedly, maybe tortiously, legal word, in a way that benefits yourself, right, or your very good friend who is an opponent of an application. And so that, and your friend who really wants a variance to be denied because it's a variance from a competitor, and you vote to deny it, and your friend takes you on a really sweet vacation, and all that comes out, right? And you're sued, and the city is sued. for tortious interference or some negligent act or some willful and wanton harm to the applicant when you voted no on the variance because it benefited your buddy. And then you went to Cabo. If all that comes out, well, the protection you would otherwise have under the Colorado Governmental Immunity Act, which provides government actors some protection, some sovereign immunity against lawsuits, that's lost. Your immunity, your qualified immunity as a government actor is surrendered, and you lose it when you act outside of the proper scope of your authority, outside of the scope of what you are supposed to be doing as a board member. The rules about conflicts of interest and disclosing them and refraining to act when you do have a conflict are mandatory. Violations of those requirements could not only invalidate the board's decision, but they can lead to criminal prosecutions as well. So you're in trouble personally and individually if you step outside of bounds. Yeah, Drew.
So I understand that if we're financially enmeshed, that would be a good opportunity to recuse yourself. But what's our standing? Say my neighbor puts a variance request in. Should I recuse myself because I may be impacted by it, even if it's not financial?
Can I touch on all this, Cameron? So I'm a general contractor, so there's going to definitely be times when I have to recuse myself. This is a small town. Everybody knows everybody. And I would ask all the board members, put aside the monetary part of accusing yourself, because you definitely need to do that. Drew, you and I will probably be the most in position to do that. However, there's times when we're going to know somebody personally that are very good friends, and everybody knows that we're good friends. There's going to be times when we live on the same street and you don't like something, or I don't like something, or some of the board members don't like something somebody's proposing. You need to, although that's not what Cameron was touching on, as a small community, we probably need to be cognizant of the fact that if you vote one way or another, that pisses everybody off, because you don't like a house, or I don't like something, or Ben or anybody on the board doesn't like something, then we need to maybe step back and say we're pretty close to this and just recuse yourself. We're trying to get the board up enough where you can recuse yourself, or I or anybody else can recuse themselves, still have enough for a quorum, and you're out of it. You have no, just the personal aspect of it. Then you don't have any issues down the road. I think it's important as a board to be professional, that there's no conflict, there's no Facebook, there's no Idaho Springs website, all that stuff that goes on with this small community. I personally would like to see this board be above the fray, and there's no issues with recusing yourself. So that's my
When in
personal
doubt,
opinion.
recuse.
Yeah, I'd like to see us as a board be above all that. I really would. So I'm just asking all of y'all to kind of keep in mind when the variances come up, if you're close to it, just back off and let the other board members have full confidence in us, or I'll have full confidence in y'all that y'all will make the right decision based on the evidence and the facts and the witness testimony and the city's packets, that we have the information that we need to make a good decision without that one person that recused themselves on that night for that particular variance. I would ask y'all to all do that. That's all I had.
Well, no, and you know what, Mr. Chair, I'm not sure if you can see the outline, but that dovetails perfectly. And I'm in complete agreement with your statement. It dovetails with the very last bullet point I wanted to cover.
Oh, I didn't see the last bullet point. I'm sorry.
That's okay. It's
Okay.
it's beautiful because we're on the same page.
Okay.
Which is
All right. All right. I
appearance
see
of
it now. All right.
Yeah, yeah. Appearance of impropriety versus the legal conflict. Those are different. And you
Yeah,
just
exactly. I mean,
you just
we're a tight knit community.
yeah.
You know how people talk, you know how people think. And if you've lived in this town for more than a year, you already got the gist of it. So, you know, just I don't want people to say, you know, the variance board is hypocritical. They're a bunch of I just want us to be professional and be respected. That's all I want.
Yep. And to your point, it's absolutely okay. I know it's hard when we have a bare quorum who's just members. So agreed, Chair. If we could get more than enough to be a quorum such that you all could know that, as I like, when in doubt, recuse. That you know that you can do that and not hamstring the city's ability to actually have these hearings. That would be lovely, and you all could give each other the grace of being able to step aside when, quite frankly, it just looks better, which is exactly what you're talking about, Mr. Chair.
Yeah, exactly. Yeah.
And that's okay. I'm fully with you on that. Here again, I'll use a concrete example of relatively recent ilk in city council. We had a former council member, he's no longer a council member, but a council member, Jason Siegel, who was employed by a local marijuana establishment. And even though Councilor Siegel had no financial skin in the game on, because he didn't own any of these businesses and he didn't get a direct pay bump for a law about how the walls had to be constructed around a cultivate. I mean, he had no direct financial impact for a lot of the general laws that council would consider that had to do with marijuana. But he didn't care because he knew that everybody knew in the community that he worked for one of these businesses. So he just, the better part of valor, said, I'm not going to participate in this because it just looks better. And he stepped aside. So, and nobody gave him any guff for it, right? It just protected everything. It protected the whole process for the rest of the council and the city. So nobody will give you grief for stepping aside out of an abundance of caution. Only other thing I will mention before I shut up and let you address anything else you want to address or talk amongst yourselves or ask is the next to the last bullet point, which is basically the gift ban. The final point, and this is so obvious that I just wanted to touch on it briefly. Y'all can't accept things of value from folks who may be coming to the variance board to ask for things. And that includes, not only things that are meant as a bribe, but that might be viewed as that. To, again, sort of the last point we just made, even if it just looks bad, even if you were offered something by someone that they would have, they would have offered to you, even despite or without you being a board member, if it just looks bad, politely decline. Or if you've already accepted something from someone who then comes before you and you didn't know they were going to, once again, just step aside. Tell us that that happened and that there was no ill will or intent, and you're just gonna sit this one out because you know that issue's out there that someone might ask about. So that's the last thing I wanted to cover. Again, I will
Cameron,
stop.
I have Diane, Cameron, Mike, I have Andrew, I have a few procedural things. So,
Sure.
for instance, if we get a bigger variance appeal or something that requires a lot more thought than 1 week of review, I would like to maybe request that we can do that. For instance, the Argo. That, I read some of the stuff on that. That was going to be a big appeal and a big variance, which would have required a lot more thought than just a week. Is it possible, if it's going to be a bigger variance or appeal, can we get that information, say maybe a set of plans, set of stuff prior to a week? That's one thing.
Good question. Yep.
The other thing is, does all the board agree to meet, Diane, the third week at 5:30, and that's the only day that we're going to do variances?
Third Wednesday.
Third Wednesday of every month. Is the board okay with that? Everybody's okay with that? I saw Drew. Is Ben and Ann with us still?
I'm okay with that.
Okay. And the third thing was, I should have wrote this down. Are we, if we have new members, Cameron, Diane, everybody, can we have them meet directly with you without the other board members going through this again?
Absolutely.
Okay, thank you.
You bet. Yes. And we
Okay.
should. Yep.
Okay. Because I think I would like to put one, I think we're trying to put one more board member, correct, and 2 alternates on?
Yes.
Okay. And if, Cameron, if you and maybe Jonathan and Mike or somebody can work with them on what we talked about tonight and make sure they're up to speed. So when we have the next meeting, we're good. Hey, Jerry. Jerry, I don't know if y'all see Jerry, but he is with us now.
Yes.
Okay. Did you get to hear most of it, Jerry?
He says yes.
Okay, good. All right.
Yeah. Yeah. No, those
All
are good questions. Chair, the only thing I can't maybe confirm, and maybe I need Diane and Mike to chime in, is your first question about packets. I think this board, if they're asking that if we have a really significant application in the future, is there any way that we as staff could commit to them to bump up our packet delivery time? That's really a burden on probably Mike, you the most, and Diane.
So Cameron, that goes back to my question a while ago, because I've been doing this a long time. I know the Argo is a big project. I understand the complexities of all the structural engineering that goes involved with the simple question that I understood was going to be on the appeal. It requires a lot of research. It requires somebody that can read plans to relate to the board members of what they were actually talking about.
Yeah.
I understood what they were talking about, but if you would have gave that set of plans to all the board members, I believe they would have had issues with understanding the difference between mezzanine versus stories and all that. And I'm just using that as a hypothetical. Okay, so
well, and
if something comes up like that, you can't just send us a little packet.
Oh no.
City's recommendations, because it won't work.
Well, and let me add, using that as an example, right? And because that is moot now, to be clear.
It is, but it might come up again down the road.
Right, correct. And
Okay.
so I just wanted to assure folks that it's okay for us to use that as an example.
It's a hypothetical.
Now, yes.
Okay.
But board members and chair, rest assured, staff in that instance was planning to have at the hearing safe built, the chief building official,
Right.
and the sort of experts that would, we hope, would have helped. I don't know what that stuff means either.
Okay, so I'm going to clarify. I am an expert at that. I could have deciphered every bit of the plan. So I could have helped the board members, but you're saying I can't meet with the board members and explain to them all the intricacies of what they were asking. So how do we handle something like that in the future?
Yep. Once again, we will, as staff, attempt to bring that expertise to you in the form of our own staff consultants. And let me also say, Chair, again, it's perfectly okay for you to bring your expertise to the table, just so long as you do it at the hearing. That's great.
So we can't have an official work session on record prior to a meeting where it's actually, we take a roll call, we say this is an official meeting, we're here to talk about a specific variance or appeal prior to something, if something big like that comes up again.
Right, correct. No way, no how.
All right.
Should you have a work session
So
on something? Yeah, before the hearing.
So we will set aside 2 hours or 3 hours for that meeting.
That's exactly right. And
Okay,
actually,
all right.
Yeah, I mean, literally.
Because I will explain it on the fly.
But bring snacks.
Okay.
And that's actually, it is true. And let me also once again say, hey, attention spans for adults and kids and are finite. And if you get 2 or 3 hours into a hearing and you feel, Mr. Chair, this is really on you. And if you feel the board sort of, just kind of being fatigued, it is okay to say.
To continue it to the next month, or can we request a special time if the board agrees beyond the third Wednesday of a month?
Yes.
Okay.
Absolutely.
Right.
Hey,
I just want to know what I can ask for and can't ask for. Okay.
You betcha. You betcha. Because there becomes a point at which it's counterproductive, right? People need to.
Exactly. Yeah, exactly. I think we're all there right now.
All right.
Drew's ready to go to bed.
I have a quick question.
Yes.
About our procedure. When we're making the decision, we should be listening to all the evidence from the staff and the applicant. And when we have our discussion, we should be addressing those 6 criteria, not just a generalized, this is what we like or don't like kind of thing. Is that correct? To make our decision stronger?
Exactly.
Okay.
Yep.
And if we make a decision and someone wants to appeal it, where does that appeal go?
District Court in Clear Creek County. Yep.
Okay.
To be the courthouse in Georgetown. There is no appeal of your decision to, let's say, city council or another city body.
Okay.
Great question. It would go right to court. Now, let me also say this in terms of board member Zimmerman's question about tying everything back to the code criteria. If you recall at our last hearing, consistent with staff member Davenport's staff report and consistent with his recommendation, there was a resolution that tracked his recommendation in your packet. So should you have decided to approve that particular application, you could have moved to adopt that resolution that had written in it the sort of tiebacks to the code criteria, right? However, still, even if and when there's a resolution of approval or denial in your packet, it is lovely for you to have discussion that ties it back to the code criteria at the end of the day. That's because we as staff don't know what's going to come out of the hearing any more than you do. So, great question.
And when the motion is made, it's usually a good idea to state before the motion what are the findings that you're basing your decision on. Because if your decision winds up having to be reviewed later, that's one of the things that the judge will be looking for is what did you base your decision on? And it can be as simple as just stating it meets the 6 criteria that are listed in the code. But that's something that we can help you with in terms of a document as part of your packet to explain what that is and how to do that. But it's very important for both you as the board in terms of your decision being upheld, and also for the applicant, so the applicant understands why did you make the decision you made.
Very good, Mike.
Other questions, other comments, other complaints?
I just want to say I really appreciate this. I think it's been very, very helpful to get a better understanding of what we're trying to do.
Good.
I agree. I wish we'd had it before the last meeting.
Yeah, me too.
That's on us. So we'll as staff, we'll try to support you better. I'm glad to hear it. Fantastic.
So I want to say, Jerry, do you have any questions? And I'm glad you finally got on Zoom with us, and look forward to having you as a board member.
Thanks for having me. I have to digest a little bit of this. I'm a touch concerned. Can you hear me?
Yes.
Okay. I'm a touch concerned that, without being able to communicate some levels of expertise on some issues, that it feels like we're constrained a little bit on making the proper decision at the end of the day, if we're kind of constrained as to our information gathering.
How are you constrained?
Well, we can't talk between us. We can't get Doug's expertise in some areas as far as, as he stated, mezzanines and what's this or what's that, and to have things, explained a little bit better. Now I'm new here, but that was just my first read on it. I like information. I had lawyer appointments today. I did my research first. I did my research first, so I had my questions and my platform prepared. And I'm not seeing that I'm not seeing the connecting of the dots quite yet, but I got time.
Well, you absolutely can get information, and I don't want you to feel constrained. You can absolutely get, like, as you said, Doug's expertise just at the hearing. And if you get to the hearing, Mr. Furry, and you feel like you're not getting enough information, I'm not sure how long you were with us, but you can always ask us for more. If we as staff or the applicant at a hearing don't give you the kind of, as you said, expert information or additional expertise or analysis that you really want, tell us. We'll get it for you. Rome wasn't built in a day, and we can certainly consider a variance more than one night.
So Cameron, Jonathan, can we make sure Jerry gets the packet that you put up on the board tonight?
You bet.
And Jerry, can you review that packet? And if you have any questions, Cameron, I know you're busy. Can he email you or reach out to you? And if he has a specific question on a certain question on the packet, can he ask you those specific questions? And can you respond to that? Or is that too much out of the realm? I know you're busy, so.
No, it's okay. It's a really good procedural question that I think for all board members, and if Mr. Furberg is appointed, he becomes a board member. And for anybody who is a member of the board, I'm glad.
So
Andy's
should he
okay.
wait till the city council approves him as a board member and then do that?
Probably.
Okay,
And as with as with all of you, what we generally do for our elected officials, and I think the mayor is the only exception, we kind of route questions from officials through Mr. Marsh, so
okay.
that he
Okay.
knows and can keep a little tab
So,
on the
all right.
on the,
Yeah,
on the
there you go,
running.
Jerry. Point that way.
Yeah. I'm like a cab, and the
Okay,
meter is
all
just
right,
like, and so I wish that weren't the case sometimes, because then people don't ask me questions. But unfortunately, we have a gatekeeper of the legal fees there, and that's Mr. Marsh.
Okay, all right. I just wanted to know the procedure. Okay,
Great
So,
question.
okay.
Wonderful.
Anybody
right.
else? Can I make a motion to adjourn the meeting?
Absolutely, you're the chair. You can do whatever you want.
Good night.
Thank you, everybody.
Thanks,
Good
board
meeting.
members. Thanks for
Thanks,
taking
Good
Carmen.
meeting. All right.
Thanks, everybody.
that.
Bye-bye.
See, Andy.
Thank you, Ben.
I like your decor, John.
I'm getting moved in.